All right, so this is the fourth uh, of our videos about online contracting. This time we're going to look at the reasonable expectations in traditional standard form contracting. So unlike the doctrines that we've considered so far, our doctrines about exculpatory indemnity and waiver clauses and unconscionability doctrine, this doctrine provides some guidance for consumers when they're actually entering contracts, just does not just provide them with some protection in eventual litigation. So let us get started. Our case is Stephen versus Fidelity and Casualty Company. So Mr. Stephen buys an insurance policy before his airplane flight at the airport. And what you see in the picture is a woman, clearly not Mr. Stephen, a woman buying an insurance policy for her flight from a vending machine in an airport. You don't see these anymore, but they're very common when I was growing up. Because the insurance companies had convinced people that flying on airplanes was dangerous, right? And there was some chance that the plane might crash and you would die. So they sold life insurance policies at the airport and at the vending machine, and you bought it just before you got on the plane. So that's what Mr. Stevens does. Now, he has to substitute a different air carrier, a different airplane during his trip. There are multiple air flights that he takes, and one of his flights gets canceled and he has to switch to another air carrier for a replacement flight. That flight unfortunately crashes. Mr. Stevens dies, and his wife wants to collect on the life insurance policy he bought at the airport. But the insurance company denies coverage, says no, he's not covered for that particular flight. Because it was excluded in the policy. The policy excludes substituting one air carrier for another. And the question is whether the insurance company is right or whether what Mr. Stevens reasonably expected when he bought the insurance policy says that he is indeed covered. So let's get a little background. There's Mr. Stevens' trip. He was going from Los Angeles to Dayton, Ohio, to Terre Haute, Indiana, to Chicago, and back to Los Angeles. And it's this flight from Terre Haute, Indiana to Chicago that got canceled, and that the insurance company claims he's not covered for that flight. So as background, his ticket, what the ticket shows is a flight from Terre Haute to Chicago on Lake Central Airlines. That flight gets canceled, and he finally ends up on what the court calls an air taxi, a charter, as we would call it now, operated by Turner Aviation, and it was that plane that crashed. So Fidelity, the insurance company's position, is that the language in the contract controls. They said, well, you're not covered, just read your contract. It says the policy restricted coverage to injuries while traveling on a transportation ticket or pass covering the whole of said airline trip issued to him, the Mr. Stephen, for transportation on an aircraft operated by a scheduled air carrier. And what they claim is that, if we can get there, we go. That's the critical part of the contract. What they claim is that the air taxi, the charter, was not a scheduled air carrier as defined in the policy. Now let's take a look. Let's take a look at the policy. It's actually relevant. This is a lot to read through, but I will read through it because we need to get an understanding of the complexity of the language that is in the contract, that the insurance company says, well, gee, Mr. Stevens, here's his contract. He was on notice that we don't cover this, right? So in the insuring clause, the first paragraph in the contract, ticket or pass requirement, the company will pay benefits specified below if during the term of this policy the insured suffers loss resulting directly and independently of all other causes from accidental bodily injury hereinafter referred to as such injury, sustained under circumstances specified below during the first one-way or round trip taken on by the insured after the purchase of the policy on aircraft operated by a scheduled air carrier, right? That is the critical phrase, as defined below from the point of departure to destination. Both shown above and return if round trip ticket is obtained before departure, provided that at the time that the insured sustains such injury, he is traveling on a transportation ticket or pass covering the whole of said airline trip issued to him for transportation on an aircraft operated by a scheduled air carrier. So what we want to know is the Turner Aviation, quote, air taxi charter a scheduled air carrier as defined in the policy? Here's the definition. Definition of aircraft operated by a scheduled air carrier. The words aircraft operated by a scheduled air carrier as used in this policy mean and are defined as follows. 1, aircraft of United States registry operated on a regular or special or chartered flight by a scheduled air carrier holding a certificate of public convenience and necessity issued by Civil Aeronautics Board of the United States of America or its successor, which in accordance therewith flies, prints, and maintains and publishes schedules and tariffs for regular passenger service between named cities at regular and specified times. That's the worry. The regular schedules and regular published schedules are the worry for the air taxi, right, which is a charter. So it flies when people hire it. Or aircraft, and so they go on and on, right? I think that is the aircraft operated by a schedule at the bottom here. Aircraft operated by a scheduled air carrier, any and all aircraft operated by scheduled military airlines, and any and all aircraft operated by air carriers recognized and the license determined by the governmental authority having jurisdiction over civil aviation as being irregular or non-scheduled air carriers. So this is the language the court has to interpret in the contract. The court holds that Stevens' reasonable expectations about coverage established that he was covered, not the words of the contract, not the words we just read. The question is, how does the court figure out what Stevens reasonably expects? What Stephen reasonably expected. Let's change it. How does the court figure out what Stephen reasonably expected? Okay, court. If you're going to say the words of the contract don't control, and as Stephen's reasonable expectations, how do we figure out what they are? And there's a 3-part approach. I have made this more explicit. You find this in Stephen, and you find it in the later cases we will look at, right? Online contracting cases, you find this same 3-part approach. But we've made it explicit in the PowerPoint slides so that we can work with it, and it's only implicit in the courts. So if you go looking for it, you say, where is it? You can recognize it if you're looking for this pattern, but you won't find the court saying, now we consider this, now we consider that. So we consider type of transaction first. Let's work through it. Let's just work through it to see how it works. We consider type of transaction first. Well, here's the court that says, characterizes the transaction in this type of standardized contract. So we have a standard form contract sold by a vending machine. We discussed that earlier. And you had this visible on the vending machine. Do not purchase more than a total of 60 $62,500 principal sum, nor for travel on other than scheduled air carriers. This policy covers a one-way trip only unless round-trip ticket is purchased before departure. So here's the term that we saw with this complex definition. But this complex definition is not on the screen. So Mr. Stevens walks up to the vending machine. Here's what he sees. He purchased his ticket. What does he think? Does Mr. Stevens think, well, gee, I just purchased insurance for my trip on the airplane, my air trip. And if in an emergency, I have to reasonably substitute a different aircraft for the one on my ticket, am I covered, right? And the court answers that yes, right? If you walk up to the vending machine, see this, and the marketing pitch is buy insurance for your trip, what do you think? Oh, well, if something doesn't work out on my scheduled, printed out airlines on my ticket, and I have to switch to another because that's the reasonable thing to do in an emergency, do they cover that too? And the court very plausibly answers, yes, they do. To look ahead, we'll compare this transaction to the ones we all enter online, right? Here is the online transaction, no vending machine, but we all know this. We scroll down and down and down and down and down the homepage. This is the Wall Street Journal. And at the bottom, in tiny little print, you find the hyperlinks to the legal terms and conditions. Right? And we want to know, that's the type of transaction we'll deal with. What reasonable expectations does that transaction generate? Here's Mr. Stevens, and the court says, well, covered by the whole trip. We want to ask the similar question about the transactions we enter all the time. What do we reasonably expect out of those transactions? Okay, so our next thing, so we've talked about type of transaction, right? Our next is reasonableness of the business practice. Now we're just working through the things the court talks about. We will eventually raise a puzzle about how all this is relevant to Mr. Stevens' reasonable expectations. But if that's bothering you, don't worry about that yet. We're going to get there. Does the court next ask, well, is the business practice reasonable? And one odd feature of this case is that the insurance company never explains why it's reasonable to exclude substitute air carriers, right? The court says, look, you see the language from the court, but to put it in more straightforward, plain English, the court says, look, you're in the business of issuing life insurance for air trips. Well, to do that, you figure out how likely it is people will die in an airplane crash, right? And in that you use that estimate of likelihood to figure out how much to charge for the premium. So of course, we don't see the difference in likelihood of a crash between a scheduled air carrier printed on the ticket, and it has, that regularly flies, and an air taxi, a charter flight that flies on higher. Why is there more danger of one dropping out of the sky than another? And the remarkable thing about the case is evidently the insurance company never addressed that. One plausible explanation is that they didn't have any good answer to that question. So the court says, look, this does not look like a reasonable business practice to us. And so that counts against that counts in favor of Mr. Stephen thinking he's covered for the whole trip, because excluding substitute carriers doesn't look like it has a good rationale. So now let's go back so that we've done this one. I do need, there we go. There, we've done that one. So let's look at words of the agreement. This one, as when we get to online contracting, this starts to play a major role in our assessment of reasonable expectations. It's not going to do here in this case because the court is going to find the words ambiguous. So the court looks at the words of the contract and it says we find them ambiguous. The language of the policy, the stuff we just read a little while ago, does not specifically exclude the expected coverage for the substituted flight. Neither the insuring clause, the first thing we read, or the definitions of scheduled air carrier, the other thing we read in section 3B, which I mercifully had us not read, negates without ambiguity protection for the emergency substitute flight. In other words, they said, look, you could read this stuff. You could read the clause either way. And then the US contract law rule in consumer contracts is if the contract is ambiguous, you interpret it in favor of the consumer. So the words of the contract are not decisive, and our other two considerations weigh, these other two considerations weigh in favor of Mr. Stephen. So the court holds he was covered. He reasonably expected coverage, and that's not negated by the contract, so he's covered. Okay, that is the pattern, and I want to make sure that we get that pattern down because we're going to use it quite a few times when we look at online contracting, right? Because we take the model we're developing for traditional standard form contracting and apply it to modern online contracting. Okay, with that in place, there is a puzzle about how this three-part test is relevant to Stephen's actual expectations. Look, it's clear. It's clear this is, right? Type of transaction. We have no problem understanding how the type of transaction is relevant to figuring out what Mr. Stephen reasonably expected, right? We go back. Here he is, we're at the vending machine. He's buying it at the vending machine in that context just before he gets onto his trip, right? And we have what's printed on the front of the vending machine, and then the court notes some additional facts, right? Because the instructions on the machine are put the policy in the mail before you get on your flight and send it off to the beneficiary under the contract, right? The person is going to get the money if you die. And so and you bought these just before you got on the plane, so there's no time to read a complex contract. And then if something does happen, like happened to Mr. Stephen, and he has to change airlines, you can't pull the contract out and read it to see if you're covered because you don't have it. There's no copy, right? So the court, so in this kind of transaction, you can say, well, gee, our question is, given the way this is setting is and given the marketing pitch by Insurance for Your Trip, what did Mr. Stephen reasonably expect? And the very plausible answer is he's covered for the whole trip. But what about these? Mr. Stephen doesn't, I assume Mr. Stephen doesn't know anything about insurance, life insurance. He's a salesperson. They don't ever say for what. I assume he's on a sales trip, right? Having meetings, maybe trying to promote sales. He knows about his business, but not life insurance. And what about the words of the agreement? How can that generate expectations in Mr. Stephen? Because we just spent some time in the earlier videos emphasizing that consumers don't read the agreements and wouldn't understand them if they did read them. So how can facts about how it's reasonable to conduct an insurance business and facts about what's in the contract that wasn't read and wouldn't be understood, how can that have anything to do with expectations in Mr. Stephen's head? That's our puzzle. And here is the solution. There is a position that contract law, consumer contracting law takes on this, and you're looking at the statement of the solution in Second Restatement of Contracts 211.3. Now, just in case no one has explained what the restatements are, let's do that briefly. So the restatements arise from the fact that the common law is not written down. Indeed, the common law can't be written down. The common law consists of patterns in the cases, and it's those patterns that are the law. So you can't write, you can describe the patterns, but that description is an opinion about what the pattern is, and the pattern itself is the law. But of course, lawyers, judges, and law students, researchers all would like the law written down, right? Well, so you can go open a book and find out what the pattern in the common law is. And that's what the restatements are. You get a whole bunch of lawyers, law professors, and judges together, and they discuss until they agree upon what the common law is, and then they write it down in a restatement, reformulation of the common law. And those are the restatements of the law. They're not themselves law. They're not a judicial decision. They're not a statute. They're not an administrative ruling. They have no authoritative force as law, but they are very, very persuasive, right? Since a lot of very intelligent people talked for a very long time to come to the conclusion that this is an accurate statement of the common law. And you're looking at this section of the second restatement of contracts, which gives its view about what a consumer has reason to, what terms are enforceable in light of what consumers would expect. So here we go. Where the other party, in that, i.e. the business, has reason to believe that the party manifesting assent, the consumer, so when a consumer enters a standard form contract and so manifests its assent, where the other party, the business that wrote the standard form contract, has reason to believe the consumer would not enter the contract if he knew the writing contained a particular term, that term's not part of the agreement. Right? So we say, gee, we've written this contract, the business reads less, oh boy, consumers are never, if the consumers knew it had that, they'd never agree to it. Yeah. So what the business does is construct a picture of a reasonable consumer, then decides what that consumer would find objectionable, right? So note what the test is. The business must have reason to believe, right, the consumer would assent if they knew the agreement contained such and such a term. It's not this, right? Number two is the same without this. The test is, what would a business have reason to believe, right? So to see how the test works, what does a business have reason to believe about consumers? To see how that works, right? Ask two questions. Ask these two questions. Who decides what terms are in the contract? Obviously the business. The business writes the contract. So imagine you're a business. You're writing the contract, and you said, are consumers going to agree to this? You're writing something along, and 211.3 requires that you say, do I have reason to think consumers are going to agree to this? What consumer? Well, a reasonable consumer. We don't want to look at unreasonable consumers. That would not be workable, right? Unreasonable consumers think all sorts of different things, have all sorts of demands. What we want the business to do is say, well, would a reasonable consumer agree to this clause? And as down here, we want the only thing that's going to work is a reasonable consumer with enough knowledge of the business, right? Not just a reasonable consumer, but a reasonable consumer with enough knowledge of the business, because that's the only way it's going to work. Think about what's in those contracts that you read. Well, we're more familiar than most as lawyers, right? You put in a lot of legalese and a lot of complicated terms to adequately protect the business. We read some of those in the we read some of those in the first couple of videos, and we just read another now. That's the kind of stuff that's in there, and it's in there because the lawyer's job is to adequately protect the lawyer's client. So you write all that stuff in there. It involves both legalese and knowledge of the particular facts of the business. And so that's the only way you can adequately protect the business. So if it's going to work at all to allow contracts to do their job of adequately protecting the business, the consumer, we imagine, is going to be a consumer with enough knowledge of the business and, by the way, enough legal knowledge to actually be able to read the contract. Right? So the business constructs a picture of that ideal consumer, and then decides what that idealized consumer, that reasonable consumer, enough knowledge of the business and enough knowledge of the law to read the contract, that's the consumer we're talking about. No other constraint about what consumers reasonably expect makes practical sense, because no other way of doing it will allow the business and their lawyers to put in the terms that the business needs to adequately protect itself under the contract. So this makes sense. Now, the reasonable consumer can assess the business practice and understand the words of the contract. And we're going to develop this view some more. It worked reasonably well for traditional offline, not online standard form contracting, as we'll see as we go along. And then our question becomes, well, does it work very well for online contracting? So we will pick up this thread in the next video, and for now we're done. Well, I will see you, so to speak, in the next video.